answer what he argues.
Then, huh?
I will answer. There's nothing to be argued in this appeal, my lord. There is only one short question, and that I can just demonstrate before your lordship.
What's the matter for arguments?
Hey, your lordship had fixed for today for final disposal. See, please see the last order sheet.
Last order is 8524. What's the matter for arguments?
Uh,
Earlier adjournment, earlier 13424. List the matter for arguments.
uh, always
Before the earlier arguments, list the matter for arguments.
number of time has been meant for the arguments.
What should I do? Tell me. What is the matter?
Matter is dead, my lordship. This is the appeal against the remand order, my lordship. By which, my lordship, the lower appeal has remanded the matter
What is
for the fresh trial before the trial court, my lordship, without set aside the decree and without reversing the findings of the trial court. As per para 20,
no, what is the final some of the last para of the appellate court order you read?
my lordship. May kindly see para 20, my lordship.
Last para there is an observation. First appellate court. What is the observation?
Please see paragraph 19 of the order.
English or Hindi?
Hindi.
Translated further,
What is the observation last?
Last paragraph clarified here that this appellate court has not reversed or set aside the findings of the trial court and has not even discussed the conclusion of the issues, the important procedural facts which are related to framing of important issues and document evidence, etc. are being sent for consideration by giving action instructions. It will be at the discretion of the trial court that if the conclusion of the additional issue and the document presented have an impact on the conclusion of their issues, then the trial court will give conclusion on the issues of the entire case and will be able to pass the decision.
Well, when a counsel makes a statement before the High Court and misguide the judge, then a heavy cost should be imposed on the counsel. Appellate court had set aside the judgment and decree and then remanded the case, and he's arguing the appellate court did not set aside the
You
judgment.
can transfer copy. Please.
Right, he is fine. He is not. The lordship has kindly translated on the record.
Para 19 में
That's please see paragraph 19.
Whether no, Mr. Counsel Senior, whether the appellate court set aside the order of the lower court or not,
Yes, when a decree was set aside.
and disposed of.
And then directed the trial court. Matlab, what happened in this case? I'm just telling in short. Appellate court framed an issue. This issue arose on the basis of the pleading of the parties, and the issue was that a suit for disposition was filed against my client. And the appellate court framed an issue that there was a stand taken by my client that he had been in respect of the house for last more than 50 years. And therefore his possession cannot be disturbed because by way of adverse possession he perfects his title. Now that issue was not framed that he was in possession for last 50 years. The appellate court itself framed an issue. And after framing the
What are the frame? What is the issue?
issue is this issue is whether the
Entered for adverse position.
whether respondent had been in adverse possession for last 50 years. This was the issue framed. On that basis, the appellate court remanded the case, setting aside the judgment decree of the trial court, to record the evidence on this issue and give the finding, and then decide the matter of merit. This is the appellate court judgment. Now, against that, he's come, and my lord, I also raised a question last time that a miscellaneous appeal against the order of remand would not be maintainable unless he points out what is the substantial question of law. The Supreme Court has said once a decree is set aside by the appellate court, and then you file an appeal against the order of the appellate court, show the substantial question of law involved in the appeal. And this was last time this was reminded, and he was directed to show what is the substantial question of law. And again, he has not shown what is the substantial question of law, and he has not done it because he only wants adjournment after adjournment to get the matter delayed. So both the counts, appellate court has framed an issue, set aside the judgment decree, and my lord, once your lordship has kindly seen, the Supreme Court has said. I am again giving a judgment of the Supreme Court, where the Supreme Court has said, once the judgment and decree is set aside by the appellate court, and remand is made, then no interference called by the High Court. This I am giving the judgment.
That is the argument both sides. Bring the remand order.
My lord, yes, ma'am.
That's for others.
May kindly see to para 19, the judgment of appellate court on two hands. In the para 19, they have said that given the finding that set aside the judgment of the trial court.
Why you are saying that not
No, my lordship. And the para 20,
whether set aside the lower court judgment or not to tell?
my lordship, para 19, finding
At para 19 or 18, ultimately set aside the lower court judgment and dispose direction given to the first court to dispose of first or not to
my lordship, it is given. At para 19, it is given. At para 20, my lordship, appellate court has
many issues are discussed. Ultimately, what is the finding of first appellate court?
This is the Bredi.
Take it advantage that the discussions in one part for in favor of you, one part is online in favor of the other side. It is not the question. Ultimately, what happened?
it may be my lordship be set aside, but
They haven't counsel for the petitioner, appellants, and the respondent submitted their arguments. What's the matter? Reserve for others. That's a
Published.
simple
my
thing.
lordship, I am relying the judgment of the Supreme Court. May kindly
You can rely on hundreds of judgments. Give it. Why not? You can rely on. Under what is the purport of judgment to read out?
My lordship, it is the purpose, my lordship, that the
Should not be reminded by
yeah, my lordship. Here, question is, my lordship, that in first appellate court, when the appellant has not remand the matter,
wasting of time. What is the issue? Additional issue framed by appellate court. You go and agitate before the trial court and see that expeditious disposal. Better.
for a moment, may kindly reply, my lordship, for a moment, my lordship, the issue framed by the first appellate court was already discussed in para 38 of the trial court.
Discussed, but no issue. That's why the appellate court is ratified.
There is no need to frame the issue, my lordship,
One minute. What is the suit filed by you?
because
What is the suit filed by you? Tell. What is the nature of the suit? Nature of the suit, what, sir?
nature, my lordship, for the declaration
What is the declaration?
Declaration of disposition.
for recovery petition, my lordship.
Why not dispose this? You have a title over the property.
This is a fair expression. So, on the basis of adverse position,
How you got the title, sir?
I have got the title, my lordship, this is my ancestral land. Given the finding that the land over which I am claiming the possession, enclosed by the defendant, is the ancestral land, belongs to me. And the defendant of encroacher, my lordship, there is a finding that para 38 may kindly see the trial court.
How much extent encroached? It is existing or
It's a house which was constructed by me 50 years ago.
My lordship, but there is a
And ancestral land without any title. How it is ancestral? By saying ancestral, you don't get
Let
title.
him argue, sir. What? You argue.
At para 38, trial court has already discussed the issue which was framed by the first appellate court. Reminding the matter that the possession of the
How
defendant
long they are residing, constructed house, residing respondents?
apart from the constructed land, they have enclosed the square feet land. Trial court has partly decreed the suit.
This
My suit, my lordship, was partly decreed.
what partly, what dismissed?
This was on the ground that the defendant constructed the house over the part of the sued land. That part belongs to the defendant, and over which they are trying to encroach.
Encroach. Erected compound wall or what?
By forcefully,
Encroached, sir. Erecting compound wall or a fencing wall or what?
yes, my lordship, for constructing the house.
Constructed house is partly allowed. Rest of the
On the one part they have already constructed the house. On the other part they are raising the construction.
which side? Which side? East or west or north or south?
This is not mentioned in the trial court
Whether you
judgment.
filed rough plan, sketch, whether you have filed a sketch before the trial court
Yes,
showing the boundaries that this matter of land, red marked land is encroached by defendant, whether you have filed any sketch
yes, my
with
lordship.
the trial court, mark with the sketch,
And with the plate, my
a
lordship.
counsel straight question I put. You are
Yes.
saying that putting the constructed by defendant, he tried to encroach it land.
Yes.
You filed a sketch showing the red mark that how much land he encroached it.
Yes, my lord. So along with the plaint, I have annexed
It's
the.
not plain, filed a sketch or not, to tell first.
Yes, my lord. So I have answered.
Sketch filed or not?
Filed, my lordship.
What is the document number marked?
Document to my lordship.
Exhibit.
Exhibit.
He will still succeed if he has a case. Even if
Huh?
the case, he will still
Next
succeed.
section.
He will
Along
still
with the
succeed.
plaint, I have filed the map over which it is mentioned, my lordship, over which part they are raising the construction. It is
Construction
filed.
is not disputed. Apart from construction, they are disputing.
Yes, my lordship. I have filed the annexer as annexer A1.
What is that A1?
A1, the map, my lordship.
It's a handwritten, hand prepared map.
Rough sketch always handwriting, huh?
Yes, my lordship. I have filed, and over which it is clearly mentioned, my lordship. The record is there, my lordship.
Both the appellants are brothers.
No, my lord. Their land is adjacent to each other.
Who is it?
What happened, my lordship? They both.
No. Appellants 1 and 2 are brothers.
They are
Yes, my lord. Appellants brothers.
Whether the property joint or any partition in between them.
They joint property, my lordship.
No, joint property joint, whether partitioned or they're
No, no
joint.
partition. Between them, there is no partition, my
No
lordship. They are between the plaintiffs.
They are our neighbor, respondents or neighbors.
No.
What is the relations or strangers or relations? If they are relatives each other or they strangers? Strangers.
Stranger are only the neighbors, my lord.
Neighbors.
Their land is adjacent to my land, my lordship.
The facts of this case appeal, you see, the defendants made house over the 30 into 20 constructors, shoot land. And the other part of also constructing 2010. You see the page number.
To the translated copy, my lordship.
No. You filed an application, phase 2. Phase 3, you see. Still under 43, you have mentioned the brief facts of this case.
Yes, my lordship.
What is 2 para 2 you read out?
Plaintiff case is brief the land bearing Kachra number 112 area.
Para 2, item 1 para 1 2. Last para.
Para 3, my lordship. That the suit land belongs to
No, above para.
above pyramid. That the plaintiff case in brief. The land bearing Khasra number 212, area 0.10 hectare land situated at village so and so. Over the suit land, defendant made encroachment and defendant made house over the 30 by 20 part of suit land, and now defendant raising construction of the house over the 20 by 10, which is also part of suit land. And map of suit land annexed as annexer A1 with the plain and marked with red ink.
You are seeking any relief for demolition of structures 20 into 10
Yes, my lordship. File the suit for the demolition.
of structures also.
Yes, my lordship. The suit was fully decreed.
What are the relief to start? What are the relief to start? 1, 2, 3, read out.
In plain, my lordship.
Plain reliefs 1, 2, 3 you should start. The first relief, another one, and another one.
Trial court decree gives the relief, my lord. The relief sought.
Decree, why need not go to decree, but the crux in the relief what he sought.
That वादीगण के पक्ष में प्रतिवादीगण के विरुद्ध demolition, the decree of demolition, my lordship, over the land which was constructed. First relief, my lordship. My second is that plaintiff, that permanent injunction. Second relief was my permanent injunction.
Still what?
First relief was, my lordship, for demolition of house which was over the suit land, that the area is 30 to 20 square feet.
What about 20?
And my lordship, the last line, that over the suit land, the constructed raising construction house also be demolished.
What is that? You have not mentioned 20 in 10. That's what amended. Letter for order.
Lordship, kindly list this matter for application, sir. Arvind Council is not available today.
What?
Arvind Council is not available today, sir. Kindly list this matter after vacation.
The land counsel for the appellant is present, stating that the arguing counsel is not available.